Hi, I'm Chris Colvin. I'm the founder of In the House. Welcome to our monthly meeting of our cybersecurity and privacy working group. I guess we've been holding these for about 2 years now with my co-host David Heckler, who's a very experienced legal journalist and is currently the editor-in-chief of the TAG Cyber Law Journal. We're delighted today to have as our guest Caroline McCaffery. She's a very experienced GC and lawyer. And she's also the founder of, the CEO and founder of ClearOPS, Inc., which is a B2B SaaS data privacy and cybersecurity company, which she launched in October 2017. So without further ado, I'll just pass the mic to David. And David, do you want to begin the discussion?
Sure. Thanks a lot, Chris. So welcome, Caroline. It's good to have you here. We're going to give you a chance to talk about your company later. The unusual, last month, those of you who tuned in will remember that we had Melissa Koch, who was the first ever co-founder and CEO of her own company and a lawyer we've ever had on the program. And she talked a lot about how she came to make the leap from lawyer to CEO. And here we are, less than a month later, and we're doing it again. It's like, whoa, there must be something in the water. It certainly isn't something that comes out of a pandemic necessarily. Anyway, and actually, Melissa launched during a pandemic, which is a whole different story. Fortunately, that wasn't your situation, Caroline. And I will ask you to tell us how you made the leap, because you were a general counsel twice before you did this. The first time at Sailthrough for a number of years, and then at Clarify, where you were also the VP of Business Affairs. So that's interesting. And that background, I'm sure, in some ways served you well, and you can tell us about that. But let's start with the main event today, you know, what we advertised. And there's truth in advertising here. So on July 16th, the Court of Justice of the European Union invalidated the Privacy Shield in what's known as the Schrems II decision. We have a timeline that we could discuss later about Schrems I, Schrems II. But we really want to know, in practical terms, what is the effect on companies? What companies are affected, and what do they have to do right now? Should they retreat and withdraw from the Privacy Shield Treaty? Is that their best move, or something else?
It's a great question. And it's a very practical question, right? And as I was saying, just as this call was starting, this webcast was starting, I got an email from the Department of Commerce about the Privacy Shield and how they are moving forward. And we have actually seen companies starting to deactivate themselves from the Privacy Shield. Here's what happens when you deactivate the Privacy Shield. You send in your request, and then they will send you back a questionnaire that you have to fill out that says why you're deactivated. And you have to make promises about everything that you transferred, any data transfers prior to your deactivation are still covered by Privacy Shield. It's just going forward, you're not going to be covered by Privacy Shield. You have to take it off of your privacy statement, or your privacy policy online. So you fill out this questionnaire, you pay a fee, and then what the Department of Commerce does is they send that questionnaire to the FTC. And so now the FTC is getting a notice from a company saying that they are no longer upholding the Privacy Shield principles. This is why I do not recommend companies deactivate from the Privacy Shield. You're already dealing with the EU invalidating the Privacy Shield, and so therefore you're under further scrutiny by the EU. Why would you now put yourself under further scrutiny with the FTC? It's a double whammy, and yes, you're still paying, you know, if you're up for renewal, you're having to pay the fees. You know, that's an individual decision. I don't know, every fee is different depending on the size of your business. But I personally would not want to recommend that companies voluntarily put themselves under scrutiny with the FTC at this moment in time when we just don't know what's going to happen.
Does this mean that the Privacy Shield does in some way still influence the behavior of companies if they don't withdraw?
So the Privacy Shield is a bunch of principles that you're self-attesting to, right? And so generally speaking, you don't want to have any implication that you're not still abiding by these principles, especially if you are a business that's doing business with European customers. I think from an optics standpoint, being able to assure your European customers that you still abide by those principles and that you're maintaining your position as a self-certified business under the Privacy Shield is important. Now, there's two things about the Privacy Shield, right? It's allowing data transfers between businesses, but it's also allowing businesses who have employees in the EU to transfer that HR data back to the US, which is a little bit more of a nuanced question. But my focus mostly is on B2B, doing business with EU customers and how that's going to affect your business. And I think continuing to adhere to the principles is a good thing, but it's not going to get you everything anymore.
Got it. I suspect that for people who are tuning in right now, whose companies do not have direct business with citizens of the European Union, what you're going to be talking about today may still be of interest and value to them, but we'll see. So you have actually advised companies about what they should be doing. You've just talked about what they shouldn't do, they shouldn't panic and make a quick decision that they may regret and they won't really benefit from. What should companies be doing, and what should specifically the lawyers at those companies be advising their clients to do?
Yeah, so I think this is an opportunity for us as lawyers to really shine. When the decision came down, the first thing I received was a bunch of calls from customers saying, well, what should I do? And for those of us who were around when the safe harbor was invalidated, if you recall that, there was quite a bit of wait and see that happened. No one really knew what was going to happen, but there were rumors that started going around saying that there was going to be some sort of new treaty. And so that's generally, lawyers especially were creatures of habit. So because that was successful when the safe harbor was invalidated, our tendency for this time around was to say, let's follow the same process. Let's see what the governments can figure out and keep the data transfers going until that time. But this time around, the European Data Protection Board said that there would not be a grace period, which is a little bit different from last time. Even though last time the grace period expired and things hadn't been worked out, so you almost draw that comparison. This time there's no grace period. And so when I was advising these customers, I started to walk down let's go through the practical step by step things that you can do in order to be prepared for when your potential EU customers are going to come at you. And that's why I put together this questionnaire. As I said to these clients, the first thing you have to do is assess the broad scope risk implications for your business. Well, what is that? Well, the first thing you have to do is say, how many customers do I have in the EU? What is the revenue hit that my company might take if all these customers said, we're canceling our contracts or terminating our contracts? But then you also have to go to your sales team and say, well, how many prospects are you talking to in the EU? Because it's not just current customers, it's also your prospects. And once you've assessed that revenue impact to the business, then you can start actually going in and digging in to get more details, which is why the questionnaire is that's the top question, right? Because it's like, let's assess because if you have $500 worth of business from the EU, you're probably not going to be spending a lot of your time doing a privacy audit because, that's a few hours worth of your work. Well, $500 is only a few hours of your time, but this is going to take a lot more than a few hours of your time. So that's why I think first step is let's figure out what the revenue impact is. Is it worth it for me to then continue down this list of questions so that when the customers start asking for comfort and asking how they're not going to terminate their contracts, how you are going to keep the data flowing, you're prepared.
So I should back up and explain a couple things to our audience. The first is this recording will be on the resource page for the Cybersecurity and Privacy Working Group, our group, but also the article that Caroline wrote for Tag Cyber Law Journal will be on there as well. And that article is where she talked a little bit about the background of this decision, and then she talked about what lawyers should be doing, and she included a questionnaire. Not only did she include a questionnaire, and we're going to show you, we're not going to hide it, we'll show you the questionnaire on the screen in a couple of minutes, but she also compiled a timeline of Schrems 1 and Schrems 2, kind of give you the framework for how this, where we are and how we got here, with sort of ... at the end, because we really have lots of questions that are unanswered at this stage. But when she refers to the questionnaire, in fact, you'll tell me when you think you're finished just sort of referring to it, you'd like to have everybody looking at it so that they can understand point by, there are 22 items on that list, and sort of where you're going with it, and what kind of information the lawyers at these companies, really any company that has business with the European Union, probably needs to compile to go to management with, to go to IT with, to go to sales with, and say, okay, here's where we are. Now we have to figure out what we think the best path forward is. So, yep. Go ahead.
So, and the part of the, again, the background, and the reason I put together the timeline, because I wanted to demonstrate how long we're going to be in this period of uncertainty. Last time it was about a year, and that's a very long time, although I guess with COVID, we're all learning how a year can either be extremely slow or maybe go faster. But it's a year, and your board of directors, your clients, they're going to be coming and saying at some point during this year, if it's, hopefully it's only a year, they're going to come to you and they're going to say, well, what does this mean? And what do we need to do? And I think as the lawyer, you have this really unique moment right now to say, I know exactly what we should do. And here's what it is. And that's my fascination, right? That's why I'm part of my building of ClearOPS. It's this, you need to pull the different pieces of information that are already within your organization together, get it organized, and then you can actually make the actions, and you have the insights, you can take the actions that are the best for your business. And it's odd for me because I'm in the business of trying to eliminate questionnaires, and yet I created one. So I'm sorry it's 22 questions. I tried to narrow it down. I think I even have double questions within a question. But I do think, I did try to make them the questions I think are the most important for you to get that big picture and funnel it down to the very specific questions you might get asked.
Let me just tell our audience, you have already said you will welcome questions along the way. So anytime you have a question, if you want to send a message in the chat window, in the bottom of the screen. Periodically, I think I'm going to have Chris unmute all the mics in case somebody would like to actually articulate the question orally. And maybe why don't you unmute the mics now, Chris? Let's just see if anyone has a question, comment.
Let me do that. I'm just going to unmute all. So give me a second. All right, everyone that's unmuted that didn't mute themselves. So feel free to speak up now and ask any questions you have. And
we'll do this periodically. I think maybe
sort of a quick question.
I think we have, yeah, I do.
From a beginner, a somewhat beginner in this area. I was wondering if you could do just a brief review of what the advantage is of joining the U.S. Privacy Shield. And I've seen some companies and general counsels deciding they don't want to formally join the U.S. EU Privacy Shield because it subjects them to European jurisdiction or FTC jurisdiction, but they still want to adhere to all the principles of the Privacy Shield. So I was wondering if you could say something about that.
Sure. So
Thanks.
thank you for your question. Yeah. So the Privacy Shield is a treaty between the United States and the EU that allows for data transfers between the two countries, right? So if you're doing a lot of business in the EU, or if you have employees in the EU, which again, I don't talk a lot about, but that is part of the Privacy Shield. In order for you to transfer that data back to the United States, whether you're hosting the data in for example, like a cloud provider in the United States, you have to have a treaty mechanism that allows for that data transfer flow. And so the benefit of joining the Privacy Shield is that you self-certify. You say, I comply with these principles. I'm going to put it on my privacy policy online, and one and done, right? Like I've gone through the process, paid my fee, and now I can enter into contracts with EU-based customers without having to put in any kind of special contract provisions. If you don't do that, then anytime you enter into business with EU customers, you're going to have a specific contract provision called the standard contractual clauses. Generally, is what they use. So it's more one by one. And so if you're doing if you're doing mass volume, the umbrella of Privacy Shield is much more beneficial for you. If you're doing a contract here or there, then SCCs, because they are standard, they actually can't be changed. Those are probably just fine for you, because it's not overly burdensome on you as an in-house counsel to review this extra, addendum, even though it's usually about 10 pages. It's not that overly burdensome.
And Caroline, I presume that because the United Kingdom has not really Brexited yet, they are still within this domain. But at some point, companies are going to have to figure out, I guess, maybe the standard, the SSCs will be what you do with the United Kingdom going forward?
So it's an interesting one. The way that the European Union works with data transfers is that they basically have the right to, this is where the whole Schrems decision kind of lays its basis. They determine whether or not another country that is not in the EU is deemed adequate. And if you receive an adequacy decision, then you don't need a special treaty with that country in order to have data flows or use the SCCs. There's not many countries that have been deemed adequate. I don't know them off the top of my head, but the United States has not ever been deemed adequate. And so the Privacy Shield was a treaty to kind of put us in that, companies that self-certified in that adequacy bucket. So the suspicion with Britain, with England, is that once they Brexit, the EU will determine them adequate because they have essentially been operating under the EU anyway, right? So already, they already have the laws and all the things in place that the EU requires in order to determine that a country is adequate. But there is some, I would say, some political bantering going on about whether or not that's going to happen.
Interesting. Would this be a good time to bring up the questionnaire? We've heard it's had quite an introduction so far. Maybe we should actually take a look at it, and you could point out things that you think our audience ought to be focused on.
Sure. Yeah, so what I will say is, and I think this is incredibly appropriate for this group, is when you're in privacy and cybersecurity, as you know, the two really do work together. So that's why the questions may start with the whole sales, as I discussed before, about trying to really understand the impact to your business before you go down deeper into the questionnaire. But at the very end of the questionnaire, you'll see questions that are getting into a much more security focus. And the reason for that is the Schrems II decision. The reason the Privacy Shield was deemed inadequate is due to US surveillance and the fact that EU citizens are not afforded protections from US surveillance. It's very nuanced. I have read the decision, so I'm oversimplifying it and understating all the details of how it came to that conclusion, but that's generally the basis for it. And so as if you determine, yes, my business is at high risk for losing EU customers, and yes, we have enough revenue from EU customers that it's worth being prepared, then what you need to do is say, well, this is what I did, is I said, well, what sort of questions are those EU customers going to ask you? Because there is a way, the standard contractual clauses are still a valid mechanism, although you will hear a lot of discussion going on about whether they still can be a valid mechanism. But let's assume, for purposes of the fact that data transfers couldn't stop overnight, that SCCs are still valid. How can you convince a customer that the risk of still using your company's products is not a great risk for them, and that they should continue operating under the SCCs until all this huge mess is figured out? And the way my brain worked on that one is GDPR, which comes into play here. You're not subject to GDPR if the data is anonymized. So that's great. If you're a US business and you've anonymized the data before it reaches the US shores, then you're not going to have to, you can go to your customers and say, we anonymize data, we're not subject to GDPR, and so therefore there's no worries. But that's usually not the case, because it does have to be true anonymization. So then you can say things, well, perhaps you can give your customers more comfort in the sense that you've never received a government inquiry, right? And that's something the legal department is going to have to determine, those questions. The anonymization is one more that comes from your security team, but that we've never received a government inquiry, never received a subpoena. But then there's a more nuanced question there that says, well, would you? Are you likely to get one? And that's where you have to dive into, well, what sort of data are we actually collecting? Would it be interesting to the US government? Because if it's not interesting to the US government, you can go back to your customers and say, yeah, we collect some personal data, but it's really not interesting to the US government. We've never received a subpoena. So I really think the risk here is super, super low. And then they're probably going to come back to you, and as you would do as an attorney, and say, well, then you should take all the liability if that happens, right? If the EU customer is all of a sudden subject to criminal investigation by the U.S. government, and you're responsible for the liability to that individual at the end of the day.
Now, Caroline, since you mentioned, the government surveillance issue, is question number 14 the kind of information that would maybe make you think that your company, if the answer is yes, we have lots of services we provide to federal, state, and local governments, would be under special scrutiny?
I think you're going to have to provide more comfort if you're a business that is doing business with a state actor of some kind, right? Because just by implication alone, you're already very much cooperating with a government entity. And that creates risk for your EU customer in terms of just the optics, that an EU citizen would say, you're doing business with, XYZ, and clearly that business works for the Department of Defense for the United States. That makes me super nervous. Even if you say something like, well, but we segregate, this is where you have to do your due diligence. We segregate the data, there's two different business streams here, and you're talking about one that's has nothing to do with the other one. We've never received a subpoena for that business stream and the data that's contained there. That's why this, I had to state the obvious in that one, I guess, which is why I put the question in there. But it does mean you have to keep asking more questions.
I'll ask one more question, then maybe we should open the mics again. But I'm wondering about, the GDPR requires some companies, and I think by implication suggests that companies have data protection officers if they're under the jurisdiction of the GDPR. And you've got Data Protection Authority mentioned here, and you've got Privacy Council in question number 15. Just, do you advise companies that you work with if they ask you, well, do we need a DPO, or should we hire or designate a privacy counsel? How do you answer that question if they ask you?
I mean, sort of like the questionnaire here, I do a little bit of fact finding. I think this decision, if you're doing business in the EU and you haven't identified who your DPA is, I would consider that now a critical task to accomplish, because the German DPA came right out after the decision came down and said, every single German company needs to cease doing business with US companies immediately. So if you're subject to the German DP, the Data Protection Authority in Germany, well, you're losing business because they just made that proclamation. Whereas if your DPA is in Ireland, Ireland is approaching this with well, we're monitoring the situation, we're assessing it, we're not doing anything right now. Right? That's good for you to have the comfort of knowing the position that the DPA is taking, that you have decided you're subject to. Whereas if you haven't chosen a DPA yet, you're in this limbo. Well, does that mean that the German DPA is going to win and all my business is going to be taken away, or is it the Irish DPA is going to win in my case and I get a little bit more of time here to figure out what to do? When it comes to the DPO question, I actually don't get asked whether or not a company should have a DPO. I usually get asked if I can be their DPO, which is always something that takes me aback because of the requirements of having a DPO and the implications of that. So, but I do think that having privacy counsel, again, if you're doing a lot of business in the EU and you're subject to this decision, you've kind of gone down this list and you're starting to get a picture of, there's stuff that's going to happen here for my business. I would recommend you go out and at least start talking to privacy counsel. There's a lot of different privacy counsels that are available, and you really need to start doing your diligence and making sure you're picking one that's right for your business. Have you ever functioned as an outside DPO for a company? I have not. I've not taken on yet. Yeah. Yeah, I wrote an article with someone who does. That's a big part of what he does. He's based in Ireland, and it was fascinating to talk to him. He had a lot of reasons why he could recommend having an outsider do the job for U.S. companies or others. It's an interesting question. Is there anything on your questionnaire that you particularly want to point to as something that's important that maybe people wouldn't think about without your suggestion? I think, and I don't really necessarily have it in here. It's a bit of a nuance, but what I've seen, and maybe it's because it's a question that's been coming up more frequently recently, is what is considered a transfer. So if you have, let's say, a team in India who does customer service for you, and they are only able to access your end user accounts on a screen, right? They have to log in and they can only look at it on a screen. Is that considered a transfer, or does the data actually have to go into a data center that resides in India? This is the question. It's a very nuanced question, right? It's access versus possession in a lot of ways. And my understanding of the GDPR is that even someone being able to see a display of it means that there's access, and that's a transfer. But there is some questions here. So basically my point being, when you're asking about whether or not data is being transferred, you have to ask what's happening with our customer service representatives. Are they, if they're based in the United States, like, let's say that you have a data center that's in the EU and the data stays in the EU and your security team is telling you you don't have an issue, make sure you look at other teams, marketing, customer success. Are they somehow getting access through the system to pull up an EU end user's data? I mentioned earlier that I was going to ask if there are lessons that companies can and should learn from this conversation, even if they're not doing business in the EU. There's the CCPA in California, and there's
a new ballot initiative in November that is on the ballot in California that wouldn't come into effect for a couple of years, but it would change everything, even in California. It would make things, I guess it wouldn't be unfair to call it more draconian, more privacy secure, more rights for consumers than exists now. And people are just getting, getting a sense of the enforcement that only went into effect in California on July 1. But are there lessons for companies that don't do business in the EU to learn from the process of the questionnaire and trying to figure out what their privacy exposure is or what issues they need to really focus on?
Absolutely. I 100% believe in this. It's like you're kind of asking a question about why I started ClearOPS, really. It's, I have been fascinated with the disparate processes and stakeholders that deal with privacy within an organization, right? So you have, one of the things we work on is security questionnaires. You have security questionnaires that are answered by the security team, but they usually come in from sales, sometimes bypass legal, and then go to security and then go back to sales. You have data breach things that happen within a business. You bring in, lawyers get brought into that, or security teams gets brought into that, but what happens with the marketing team? Like there's just a lot of silos that are within the organization that need this cross-population of information in order for the organization to actually be able to to take the best actions when it comes to the end user's data and actually giving them privacy. And so that's what the CCPA is basically mandating, as well as New York Shield. There's other laws that don't receive as much attention, but certainly have been going down the same path, which is to say, we know that there is data all throughout the organization. We know that there's people who are involved in it in many different ways. You need to get that organized, and you need to know where it all is, so that when we come and ask you to prove to us that you're actually treating people's data with privacy that you promised, that you're doing it.
I think we should open the mics for anybody who wants to ask a question again. And you wrote an article about security questionnaires for us, and I think I'm going to send it to Chris to post next to the article you just wrote about the Privacy Shield, so our audience can see both of the articles you wrote about questionnaires, and these are both questionnaires you did yourself. And I think I'll open it to questions, and there's a chat, something in the chat window here. And afterwards, I'm going to ask you to tell us how you decided to take this leap and start your own business. But first, let's see whether there are questions out there that anyone wants to share.
Yeah, I see one from David about using third-party companies like TrustArc to assist with the EU-US Data Privacy Shield and GDPR compliance. I do have a client who works with TrustArc in addition to us, and I help them with that engagement. And I don't want to comment on specific third-party software and about this, about what their offerings are. However, I absolutely think it's important that if you're looking to self-certify in the Privacy Shield and you're not a privacy expert, using a third party is absolutely fine. I think, like, my business is all about trusting third parties, so do your due diligence on them, definitely. Make sure that they're going to actually provide you with the services that you're looking for assistance with. You can self-certify in the Privacy Shield. I don't know if I would do that right now if you haven't already done it. When it comes to GDPR compliance, yeah, I do. It's a big law. It's a big regulation, and I think people need help. And so I would highly recommend a third party on GDPR compliance. Again, whether you go with a law firm versus a software provider is your choice, but I do think it's one of those big regulations that everyone needs help with.
Okay, if there are questions.
If no one else has a question, I do. It goes back to the beginning of the discussion, Caroline, and I'm curious to hear more about ClearOPS, and this relates to David's question. Why did you start ClearOPS? What do you guys do exactly? And when would a potential client know when they need your services? So we have a little better sense of how you and your company fit into this overall discussion.
Sure, thank you for that. So I, as you mentioned before, I was general counsel to 2 companies. Before that, I was outside counsel. And when I was general counsel, I kept running into the problem of security questionnaire, which I've talked about, which is essentially a sales team. I'm helping them try to close a deal. Potential customer says, we're good to go. You need to do the MSA and the security questionnaire. And so they would send both of them to me, and then I would have to go running around the organization, try to find anyone who had any information about security to try to get the answers together. It would take days, weeks, months sometimes, because these questionnaires can get very long. And it was painful. It was so painful. And I talked to all my Tech TC colleagues. All of them complained about it. Such a horrendous process. As lawyers, you feel helpless, right? Because you can answer the policy questions, but that's maybe a tenth of the entire questionnaire. And your security people are looking at you like you have 2 heads, because why do they have to fill out this thing? Their commission isn't based on this thing getting done, and it's just a horrible experience. And I worked with my co-founder, and I said to him, is there any way that we can truly automate this? And that's why we decided to build ClearOPS. We have truly automated it. So you can be the legal champion in your organization. You can oversee security questionnaires. You can make sure they get done more efficiently, of course, but even more, I'm actually much more fascinated with the answers that your company is generating and be able to provide you with actionable insights into that. And then we also launched a second product that is very complementary to it. So it's, you're responding to security questionnaires as a company where you're also wanting to do due diligence on your own vendors. Mm-hmm. And so our second product is vendor due diligence, but we don't require you to send out questionnaires, because I don't really believe in that being the best process, even though we're helping companies respond to them. So we do a public data report. So we find information that's publicly available about your vendors, and we report on it to you. Things such as, like, do they use cookies? How are they using cookies? Who is their cookie manager? Do they have encryption in transit? These types of things are very important from a privacy and security due diligence perspective, and it's all publicly available information. So you have it at your fingertips. We don't believe in telling you what a score is. I'm sorry if other people believe in that, but we don't. We believe that you need to make the decision for your company for yourself. So we're providing you with the data, and you make the decision.
And was it this need, this pressing need, that made you decide a company should be formed to answer this and to fill this need?
So as you mentioned, I was VP of Business Affairs at Clarify. My role from general counsel expanded there to really run the entire business side of the company, and it gave me a taste of what it's like to really run a company. And it was frustrating to, frankly, it was just frustrating to never be the one who could make the final call. So I was sitting there the entire time, giving advice, and waiting for my advice to be executed on, and eventually seeing that it would be executed on and the benefit of it. And I just felt like I needed to go out and do it myself. But I'm a lawyer, so I de-risked the venture before I even started it, right? So I went out and I polled hundreds of people. Is this a problem? Is there a market? And then I've spent the last year convincing investors that there is a market and they do need to support this business. And it's almost gratifying to see competitors pop up, because it shows that there's such a huge need.
Has the pandemic made your life harder than it already was? Or
yes.
Yeah.
So like you're the woman who you had as a guest last month.
Right.
She launched during the pandemic. even though the reason we've been around so long is because I'm a lawyer. I could incorporate us at the drop of a hat. That was not hard. The harder part was starting to build up a product. And we officially launched our security questionnaire response product in February, which we had great momentum going into February, and then COVID hit, and it's been a challenge. Just in terms of marketing.
So what, as long as we're talking about sort of your transition from a lawyer to a business person and a founder, I guess what most surprised you perhaps about going through that process? Like what did you learn, and what was surprising to you about being a CEO after many years as a lawyer? I guess if I really thought about it, there would be a lot. I was about to say not much, but there probably would be a lot. I think my experience of being a VP of operations, business affairs was very valuable because I knew how to hire from that experience. I was responsible for HR. I knew how to do a lot of things that as starting a company, you need to have that experience. Right. The things that I was not used to was the raising money, the finding a place for us to all work with COVID, the going remote and building that team bonding with a brand new team in a fully remote way. So it's the constant new challenges, the constant changing of the business, and the pivoting that happens. These are things that as a lawyer, it's a little bit more steady. In terms of, you may get thrown surprises, but you kind of know what surprises are going to hit you, especially after 20 years of practice. Right. So I find all of it incredibly fun and challenging.
Even all the details. I've talked to people who are, CEOs of startups, and one of them said, everything is your problem. If one of your employees' wife has a toothache and the insurance is a little balky, that's your problem. If you need to boost morale by getting candy bars for Friday afternoon when people were still together, that's your problem. You got to go out and get every little detail is your problem. Has that been your experience too?
Definitely. Yeah, I haven't heard it phrased quite like that before, but it's 100% true. I know what's going on in everybody's life, which is funny to be a privacy person and be somewhat cagey myself, and then yet know all these things that are happening in my employee's life. We do have a question that just popped up in the chat. I don't want to not be able to answer it because I know we're near time. So will using the standard contractual clauses for controller to processor work for data transfers back to the US from a processor? So standard contractual clauses are very much the hot debate. It's what everyone is going to use. In fact, if you read the TechCrunch article about Schrems suing, I think it's over 100 companies under this decision. Facebook still relies on Privacy Shield for a couple of their business units, and they're saying they're going to go to SECs, but everyone's like, well, are SECs still valid for those? So they will work for now. Generally, that's again, German DPA says no, but generally speaking, most DPAs and most companies are using the SECs for now. But again, we're not really sure what's going to happen in the future. So I highly recommend, again, to go through this questionnaire so that you're ready for the questions that the EU controller may be posing to the US processor to make sure that the SECs will remain valid, or at least hopefully remain valid.
Well, part of my job as moderator I don't like is I have to call time. So we are at 12:50. So we could perhaps take another question if someone has one teed up. But I want to make sure this would probably also be a good time to say, since there are a bunch of lawyers on the call, that nothing that Caroline or others say should be construed as legal advice. These are just background information for people interested in the topic. I'm sure Caroline would agree with that, that please don't construe anything she said or others said as legal advice. But I want to take the opportunity to thank the co-host of this program, David Heckler, as well as Caroline McCaffery, and also congratulate you, Caroline, on launching a successful business during a very difficult time. So I always admire lawyer entrepreneurs, because it is you know, a unique role to have in the business world, to be a lawyer who sees an issue and spots a problem and launches a business to solve that problem. So I very much admire that and appreciate your time today. So David, I mean, we could take maybe one more question if there is one, or if you want to get the final word.
Just reiterate our thanks to Caroline, and good luck. Stay safe, stay solvent, keep doing what you're doing. It seems clear that this world is only going to get more complicated as far as privacy is concerned, and people are going to need help, and like yours.
Yep, and I see Caroline posted her email there, so presumably she'd be okay with folks reaching out. Caroline at ClearOPS.io. Certainly you all can contact me as well, Chris, CHRIS, at inthehouse.org. So we will be posting this video probably next week. My tech situation is not great, so I probably won't be able to process the video till sometime next week, and we'll post it on the site and then post it to various social media at that point as well. Well, thanks everybody. We'll be back next month with another interesting speaker in the issue of cybersecurity and privacy. So please join us for our monthly sessions in the future. And you can also go to inthehouse.org and go to resources and see some of our prior webcasts from the past 2 years. We started in August of 2018, David, if I'm remembering correctly. So we've got quite a data bank of prior programs as well. Thanks again, Caroline, and have a wonderful weekend, everybody.